Violent disorder is an offence under Section 11, capital A, of the Summary Offences Acts of 1988. The maximum penalty for the offence is 6 months imprisonment and or a fine of $1,100. It is a summary offence, which means it must be dealt with in the local court. For a person to be found guilty, the prosecution must prove 3 things beyond reasonable doubt. The first is that 3 or more people were present together. The second is that they each used or threatened to use unlawful violence. And the third is that their combined conduct would cause a reasonable person to fear for their personal safety. Now, the law says that it doesn't matter whether the people threatened or used unlawful conduct at the same time, and also that the offence can be committed in private, so for example in a house, as well as in public. The law also says that the violence or threatened violence can be towards a person or towards property. However, it says that importantly, if 3 people are charged with the offence and one of those people is later found not guilty, the other 2 must also be acquitted. Violent disorder is rarely charged by police, and that's because there's an offence called Affray. And that offence is similar in some respects, but it is easier to establish in some ways, and importantly, it carries much heavier penalties. Affray carries a maximum penalty of 10 years imprisonment. It is what's called a Table 1 offence. That means it can be decided in the district court as well as the local court. So what's the importance of violent disorder? Well, the importance is that if you are charged with Affray and the evidence against you is strong, then a good lawyer can ask for the Affray charge to be dropped on the basis that you plead guilty to violent disorder instead. And that, as I've said, carries far lower penalties. So if that occurs, your lawyer may well be able to push for what's called a Section 10. That means that you are guilty, but no criminal conviction is recorded against you.